All right. Good evening, folks. Welcome to Kirk's Law Corner Monday Night Law. Oof. What is this? August 14th, 2023. Time is cruising right along, is it not? One day at a time. Flies right on by. Hope everybody enjoyed their weekend. I had a pretty good time up there camping, relaxing, and boy, what a relief up there. There's absolutely no service of any kind anywhere. No cell service, no nothing. No services, no gas stations, no nothing for miles. Basically a couple of hours in any direction and you could find a gas station maybe. But yeah, it was really, really good to get away from all of the RF. And I tell you, I could totally feel a difference up there getting away from all this RF, radio frequency stuff here in town. It's crazy how a body feels different. A lot more energy. Just, I don't know, just feels better, I'll tell you that. So, anyways, Brother Rob, how you doing? See you out there on Facebook. CC, how you doing? And let's see what we got over here. Anybody over here on Rumble? Oh, there's a couple, 3 people watching right now. And one over here on Telegram. Corruption Detector, how you doing, brother? I am really surprised that that one channel over there didn't take the video down yet. Give me a strike. I don't know. Maybe they just haven't gotten to it yet. But I don't know. A couple people are asking me to keep it up. I get it. But the problem is YouTube doesn't like that. I was actually not going to mention their name, but anytime you mention any of those key words, they'll strike it down and give your channel a strike. And I've already got one that's back on there again, and this would be number 2. So I don't know. We'll see. But yeah, good stuff on that last video last Monday night, huh? It's the truth be told, right? And the things that are going on is being played out. It's a show. Now, I get that there's still deep staters in some positions on a lower level type thing. Mostly down here at a state, county, and city level. But a lot of the upper echelon world stuff, world stage, look, people, that stuff's been taken down. Aside from what's left of going on in Ukraine. And then it's going to be here. Now there's even talk about Australia and some other things going on down there. Excuse me, I actually finally got to eat for the first time today. I just got done with that and I was starving. But, this is going to become more and more prevalent here in America. Of course, we're going to be last. That's just pretty much the way it's going to be. Sometimes I say saving the best for last. Well, it's not just that. It's this other things that had to be taken down first. And then again, this has to come out in a way where it wakes the people up. So when it does get applied to other people, well, wait a minute, you were all giddy up, go to go after Trump when they were going after Trump, And then, things like the Presidential Records Act. He's already said it. We already know this, to those of us that are paying attention. We know that under the Presidential Records Act, he declassified those documents and took them as evidence. And then it was a setup, right? And then what's the setup? It's a setup. What is he talking about out there? Biden. Okay? Biden being one of them, being in possession of classified documents that he's never been president prior to all this. Never really has been president of a bankrupted, involuntary bankrupted corporation at best. But how do you if it's been involuntary bankrupt in June 20th, 2020, how in the heck is it gonna president of what? It's done. So, again, Derek Johnson pointed this out, and I admit again that I missed that because I wasn't, fully aware of the symbolism. I knew there was something different, something was off about supposed inauguration, which I explained last week, but that was a funeral procession. So how could this so-called Joseph R. Biden be acting as president right now? Because it's all just a show, folks. All of it. Again, many people have already been executed. We got to see Bush Sr. and John McCain. Now, we didn't get to see the actual executions, but we sure got to see their funerals. Are you telling me that both of them just magically died all of a sudden after Trump got into office? Give me a break. Pay attention to that one video that keeps floating around out there that's showing those envelopes falling out of people's I just had it on the tip of my tongue. The paperwork there for the funeral. Okay. So that stuff, they were given notice, right? That would be what I think is in there. We have it all. And they're busted. My guess is a lot of them probably got arrested right after that. So, people for evidence and all this stuff. We're not going to have that readily available. Okay. That's the evidence. You get to see it. And those are two undeniable, evidenced deaths. And again, use your thinker here. Is just all of a sudden both of those two people happen to just die after Trump got into office. Come on. A little bit of discernment, maybe. Diesel Days, what's up, brother? Oh, yeah. Yeah, there are definitely some weird stuff with that so-called inauguration. But tonight, I want to talk about the stuff going on with Ammon Bundy. Okay? And now, I'm going to have to pull this up. One of his later videos here. I wish I had a little bit more time here to get prepared for this, but there's kind of a plethora of videos out there. And a little background for those who are not aware. These folks had their baby taken from them on the street corner at Chevron, right down the street from me here, to be honest. It was pretty crazy. And, in fact, Wait a minute. There we go. Hope everybody on Rumble can see that, because I swear I already screen shared. But all right, come here. So there's their little baby Cyrus. Okay, and this is his little short 4-minute video that he did here a couple months ago, and kind of talks about some of this stuff, and it shows right in the very beginning here what went down. Now, again, a little background on this again was the fact that she actually called in because she wasn't feeling very good. Now, remember, we're still in the middle of this whole supposed COVID thing, right? She wasn't feeling very good and was supposed to take him in for just a routine checkup, you know, based on the plan that they had going on for him, because he did have some eating disorder stuff and a stomach disorder, and really could only tolerate the mother's breast milk. That's pretty much all he could really handle. Sure, he's a little boy, but if you know their parents, they're not very big people to begin with. So, kind of like, yeah, so child's still, for the most part, healthy. And we're going to get into some law stuff on that after this. So for those, you know, CPS and that kind of stuff, what's involved here in police, and kind of revisit some of this stuff that's already in my educational series. If you've watched them, you'll kind of learn some of the same stuff here. But without further ado, let's go ahead and play this video here. And the other part of this is, you know, St. Luke's suing Ammon Bundy and Diego for supposedly libel and slander, which would be a suit at common law, criminal in nature, not civil in nature, because libel and slander is common law. So it wouldn't be civil in nature, it'd be common law, criminal in nature. Because that's the way libel and slander is. There is no civil when it comes to libel and slander. You either did it with an evil motive or you did not. And if it's true, it has to be proven with an evil motive. Well, I don't see any evil in exposing St. Luke's and their child trafficking and their... Hey, I was down there. And now I'm going to put this out. And I've shared quite a few of the videos on this stuff over the last year on this stuff. Why isn't St. Luke's coming after me? Wonder why. Oh, one is probably a political agenda. But let's go ahead and play the video here, and let's see if you guys can catch wind of what's going on here. And some of you may already be aware of this or aware of the situation very similar to your own, which is in part why the reason why I'm going to go over this again tonight. Okay? So 20 minutes after she called and said, I'm not sick, I'm sick, I'm not feeling good, I'm coming in, I'm not coming in, and I want to reschedule. 20 minutes after that call, the hospital is calling CPS.
Arresting him? Guys, they're trying to take baby Cyrus from us. My husband's getting arrested.
We're not going to screw with you, you understand?
For what?
Okay?
Please don't take him.
I won't take him. I'll stand right here with you. We're going to take him to the hospital. And if you want to go, you can
Can I ride with him?
Yes,
Please.
you can. Okay. We'll get an ambulance here to transport you guys.
Thank you.
Okay?
That officer, if you couldn't quite make out what he was saying there, was, yeah, you can go with him. He's just going to go to the hospital. He's got to go for his checkup, see? But see, none of this is a cause of action. It doesn't meet the governmental compelling interest. It doesn't pass the strict scrutiny standard test that's required in order for them to take any action. But we'll get into that. Back to the video.
You good?
You're gonna want this.
I can't. I'm sorry. I'm not gonna leave him.
Well, this is how it's gonna be.
I
Okay?
can't leave him. You understand what happens when the state takes custody of babies? I've seen this so many times. I can't be that next person. I can't.
At this point, you need to give him to the EMT, and you can go on your merry way with your friends and your family who's out there.
That's not Mary at all.
Or I remove him from you and you go to jail. You need to make that decision. You need to make it now, please.
I won't let him go.
Okay. No, she's going to jail.
Put your hands on your back, okay? Let's go this way.
Last year, CPS took a child away from his loving and caring parents, a baby. They took this baby away against his parents' will and were planning on sending him away with foster parents. All while the hospital was misdiagnosing the child and barring his parents from seeing him. That's when I stood up. I took a stand and united people. And within 6 days, because of our work, that child was returned to his grieving parents. Since then, I have been buried in legal paperwork, lawsuits, summons, and now arrest warrants, all for fighting to ensure this child was safely returned to his home. Facing a $7.5 million lawsuit, I'm being threatened with jail time, and the court has authorized them to take everything I own. Is this what it means to be an American?
Ammon Bundy now has a civil warrant over him filed by St. Luke's Health System.
No. Americans don't turn a blind eye when they see something wrong going on around them. Americans don't accept the law or anything else when it's wrong. Americans fight for the weak and the innocent. Americans push off fear in the face of danger and bring justice to all they can. Americans refuse to be governed by those who hate liberty. I don't know what's going to happen. I don't know if I'll be in jail by the time you see this. But what I do know is that if you take a stand in America today, the law will not protect you. In fact, it will allow you to be crushed by those who hate this country and have lots of money and lots of power. Is this what you want for the future of our country? I certainly don't, and I don't think you do either. I believe we can change this, but I can't do this without you. This isn't only about one baby. This is about our entire country, a whole generation.
All right, and then Ammon Bundy was actually just arrested. 2 days ago, two nights ago, at a banquet party. Okay, that was not lawful. That part of that civil warrant, right? But we all know that warrants must state with particularity the place to be searched and the person or thing to be seized. And then warrants specifically state on the warrant itself, bring him before me. Or, if I'm not available, the nearest and most accessible magistrate. Okay? That's the law, the common law. And it's on every single warrant. The problem is, and there's supposed to be a court seal on there. Okay? A lot of these fake warrants that they have out there now never describe the place to be searched. They just say, oh, in the state of Idaho. No. Must state with particularity the actual place, because state of Idaho is a corporation of fiction. And you can't put in there the territory of Idaho. Well, anywhere. No. That's not how a warrant works. Okay? Warrants are supposed to be executed by the sheriff. They are to be delivered to the sheriff. And the sheriff, okay, is supposed to execute that wet ink signature, wet ink court seal or raised court seal on that original warrant. And then take it to where it says to go, the place, and search and seize whatever it is that's listed in the warrant. And then in these particular warrants, bring him before me. The other part is misdemeanor warrants can't be served at night. No. Can't even make arrests at night for misdemeanors. Unless it involves what? Breach of the peace. And then it only goes so far as stopping the breach of the peace. See, this is one of those play on words when they think arrest means you're going to jail. No. Arrest is stopping somebody, depriving a man of his liberty, whatever. Okay? Any deprivation of our liberty is an arrest. Hey, you, stop. Bam. That is an arrest. Okay? And then things like taking kids. Now, for those of you been around for a while, may have heard me say this once, maybe twice, because that's all I've about said it. But I was the kid back in 1985 who was kidnapped by the CPS of the state of Washington. About a month before I turned 14 there. So I know what it's like to be the kid that's taken. And have the caseworker, three or so months into it tell me, if your mother loved you, you'd already be back home by now. Yeah. That's where I stood up, reached across the desk, and socked her in the mouth. Don't you ever talk about my mom like that? So I know firsthand knowledge, experience of the corruption of how CPS works. And how they lie and all that good fancy stuff, right? So let's take a look at just some, look into the code, folks, right? And before we get in, it's over here. Before we get into the code, or before I get into the case, we're going to get into the code. So this is our Idaho Code, statutes, what have you. Oh, where is it? Oh man, I'm kind of. Oh yeah, there we go. Title 32, domestic relations. So for those of you that remember me covering this particular part here about unity of subject and title, they don't have subject matter jurisdiction over domestic relations. That's the subject. That's the unity of subject and title. Well, they don't have. First, they don't have personal jurisdiction. Right? Oh, persons. What's a person? Minors defined. Males under the age of 18 years of age. Females under the age of under 18 years of age. Provided that any male or female who has been married shall be competent to enter a contract, mortgage, deed of trust, bill of sale and conveyance, and sue or be sued thereon. Okay, Okay, this says 1863 is when this originally came around, which is weird because our Organic Act for the Territory of Idaho was 1863. I'm not aware of anything in 1863. It was 1864 was the first legislative session for Idaho, for the Territory of Idaho. But the problem is if they're a minor, then who has the authority? Oh, that would be the mother and the father, or more specifically, the father. From the common law, the father has all the power. And this is, again, listen carefully, folks, the change of words, diction. Notice that they use child and parents. We need to switch out them words, jurisdiction, and change the jurisdiction back to common law, which is mother, father, son, and daughter. Okay? Anytime you're looking in here, you're going to see that. You might see mother and father in here every once in a while, but they always refer to parent and child. It's trickery. Now, here's one of them contracts, right? Here's a subversion of the law. What constitutes marriage? No common law marriage after January 1st, 1996. Who are you to dictate to us that we can't get married on our own because that's a free exercise of religion, right? Because, again, marriage is a religious act. They don't have subject matter jurisdiction. This is common law, God's law. All right, let's go look at this. What constitutes marriage? No. Marriage is a personal relation arising out of a civil contract between a man and a woman. Uh-oh. There's some liberal nut jobs out there going to have a hard time with this one. To which the consent of the parties capable of making it is necessary. Consent alone will not constitute marriage. It must be followed by the issuance of a license, and a solemnization is authorized and provided by law. Bylaws of a corporation get to issue a license. Last time I checked, we don't seek permission to exercise a right. And license is seeking permission to do a thing that would otherwise be illegal. So this is subversion of law. Subverting God's law, the common law. Marriage created by a mutual assumption of marital rights, duties, or obligations shall not be recognized as a lawful marriage. Really? Well, we don't need the state to recognize it because it has nothing to do with them. They don't have any authority over it to begin with. But here again, it's a contract. And that license is from where? From the state. So you get that state is the parent under Parens Patriae. The state is the parent. That's Old English under the Roman civil law, the Roman Catholic Church, the code. Okay? No, and no. So, the license is unlawful. I highly recommend anybody who's got one with the state, because that's your third party over there to a contract, you don't even realize it, is to nullify that contract on the grounds of fraud. You don't seek permission to get married from government. Do you have to go to your neighbor and ask your neighbor if it's okay to get married? because that's exactly what it is, right? The people. Of the people, by the people, for the people. All right. Now here we got husband and wife. But let's take a look at this. This says parent and child. But look at what it even says. So again, replace these words with father, mother, son, and daughter. It's not there. This is the jurisdiction. You use these words, that's juris, body of law, diction. These are the words of this domestic relations, the code, the bylaws. Let's look at this one right here. Liability of parent for child's necessities. What are the necessities? If a parent neglects to provide articles necessary for the child who is under his charge, according to his circumstance, a third person may in good faith supply such necessaries and recover the reasonable value thereof from the parent. Well, that sounds pretty stupid. And it's void for vagueness. Provide articles necessary? Where is it? It's 1010. Okay, here's their so-called Idaho Parental Rights Act. So now they're thinking that they have the authority to dictate to us what our rights are here. We did an act. We're going to create your rights, tell you what your rights are. Because we need a law for that. It's already the law. It's called the common law or God's law. The laws of nature. All right. But let's read what they got here. This section through section 3210.14 Idaho Code shall be known and may be cited as the Idaho Parental Rights Act. The interest and role of parents in the care, custody, and control of their children are both implicit in the concept of what? Ordered liberty and deeply rooted in our nation's history and tradition. That's right, it's off limits to government. Oh, I love this next part. They are also among the unalienable rights retained by the people under the 9th Amendment to the Constitution of the United States. Oh, well, 9th Amendment, not 14th? That there are other rights that are retained by the people that are not enumerated here. To quote James Madison and at the convention on the Bill of Rights, that there's so many rights to try to enumerate. It would be impossible to enumerate them all. Think about that for just 1 minute or two. That there are so many rights to even attempt to enumerate them. It would be impossible to enumerate them all. Now I'll say this again, for those that aren't aware, there was originally 156 or 157 proposed articles in the Bill of Rights to begin with. So they were actually trying their best to enumerate a crap ton of our rights. Oh, no, we don't need to enumerate those. I say we should have. I say we should enumerate as many rights as we can in writing for these jackwagons out here that seem to think, well, it doesn't say that over there and it doesn't say that there, so you don't have them rights. That's exactly the whole point. So as we can see here, it's very plain and clear that one, the concept of ordered liberty and deeply rooted in our nation's history and tradition. They are also among the unalienable rights retained by the people under the 9th Amendment to the Constitution of the United States. The interests of the parents include the high duty and right to nurture and direct their children's destiny, including their upbringing and education. Okay, so this precludes government. Period. Done. The state of Idaho has independent authority to protect its parents' fundamental right to nurture and direct the children's destiny, upbringing, and education. Upbringing, that's that part of any kind of health issues they have. Now, the protections and rights recognized in sections 32, 10, 11 through 10, 14 Idaho Code are rooted in the due process of law guaranteed pursuant to what? Section 13, Article 1 of the Constitution of the State of Idaho. Huh. Really? Well, let's take a look at Section 13 of Article 1, the Constitution for the State of Idaho. Guarantees in criminal actions and due process of law. What do we got here? In all criminal prosecutions, the party accused shall have the right to a speedy and public trial, to have the process of the court to compel the attendance of witnesses in behalf, and to appear and defend in person and with counsel. Where does it say a member of the bar? I don't see where it says member of the bar. And then, no person shall be twice put in jeopardy for the same offense, nor be compelled in any criminal case to be a witness against himself. Now this is where this comes in. Nor be deprived of life. Little baby Cyrus and all everybody else's babies, including myself when I was 13, that is our life. And it's not a liberty interest, it is a life interest. Because we're among the living. Right? And when we procreate, we create life. We don't create liberty, we create life. So in order to deprive life or liberty or property, you have to follow due process of law. Not the code, not the statutes. Because, what? Due process of law is synonymous with law of the land. This is the law of the land. So it has to be done in accordance with this here. Nothing else. We don't need to refer to anything else for due process of law, other than the common law, which was long antecedent to the formation of this Constitution, by far, and before any Constitution for America. So this is why you have to know your rights. You have to know what the letter of the law of the land actually reads as it is written. I know my rights. Right. Read it. Learn it. Know it. There is a process that is due, depending on who you are. But on this right here, refers right back to here. That's what this says. But watch where the contradictory is here. Governmental efforts that restrict or interfere with these fundamental rights are only permitted if that restriction or interference satisfies what? The strict scrutiny standard provided in Section 32.10.13 Idaho Code. Now, watch this. This all sounds good, right? It all sounds really good because that's the truth. But then you get to number, nothing in this act shall be construed as altering the established presumption in favor of the constitutionality of statutes and regulations. No, we don't need any statutes or regulations regarding these rights, because these rights don't come from government and they have no authority to regulate them. None. We're in the private. Period. Good question now here on Facebook, Tammy Woods. What does that mean depending on who you are in reference to due process of law? Okay, if you're a judge, you have to go to the legislature to remove their immunity from being sued. It's called impeachment. The right dictates this process, right? The law of the land does. Right here. Political power inherent in the people, the right to alter, reform, or abolish anything at any time we deem it necessary. Right? All political power is inherent in the people. Government is instituted for their equal protection and benefit. This is what government was instituted for. This is their duties to perform. Right there. That's it. That is the only sole purpose the government is instituted, for our protection and benefit. Not to be used against us. Okay, but hold on. And they have the right to alter, reform, or abolish the same whenever they may deem it necessary. Now, and no special privileges or immunities shall ever be granted that may not be altered, revoked, or repealed by the legislature. Okay, so this process is what is due to judges. And they can only sit there so long as they act in good behavior. Well, if they're denying justice, that's not acting in good behavior now, is it? So this is where you would go to the legislature, where this right dictates that we go to the legislature for the redress of grievances, and we do the petition as a political lawsuit for the redress of grievances, right? And that's how we assemble, right? The people shall have the right to assemble in a peaceable manner, to consult for their common good, to instruct their representatives, and to petition the legislature for the redress of grievances. So read this backwards. You file the petition, they assemble, so that we can consult the people, us, consult for our common good, and then we instruct our representatives, which means we're the boss. They're the servants. We're the masters. They're the servants. Okay? They do what we tell them to do, not the other way around. Servants never have the authority to dictate to their masters anything, ever. Fundamentally and principally, you're freaking insane off your freaking rocker if you think you're a public servant and you get to dictate to us people anything, ever. You check yourself into the hospital before you end up there. So let's just go into their Idaho Code some more. Those ethics in government, morals and ethics. Transparent and ethical government. This is one of my most favorite ones for Idaho here. Although it talks about open meetings law, a lot of people go, oh, well, we able to go to these executive branch meetings. That's not what this is supposed to be, and that's not proper form of government. But let's take a look at this. Formation of public policy at open meetings. The executive branch doesn't make law. They don't make policy. The legislature does. Right? The legislature is supposed to do the creating. The executive branch is supposed to execute that which is created by the legislature, the laws of its creation. See Hale versus Hinkle. The people of the state of Idaho, in creating the instruments of government that what? Serve them. That means they're the servants. That we are the masters, because that's the reciprocal of servant, is master. Whether people like that or not is irrelevant. That's just the truth, the fact, the cold hard truth. Don't like it? Don't become a servant. Don't receive the emoluments of that office. Don't receive those advantages, profits, and gains as a servant of the people. But if you do and have a servant's heart, and you want to serve the people with good intentions, go for it. Do it. I'll support you in that. What does this say? Do not yield their sovereignty to the agency so created. This destroys the whole sovereign citizen argument, because it's a sovereign people and they're the citizens. Remember? Law of Nations, Book 1, Chapter 19, subsection 212, the definition of a citizen is the public servants. Those members of the legislative branch, executive branch, and judicial branch, whether state or federal, shall be bound by oath or affirmation to support this Constitution. That's right. Members of a civil society who are bound to perform certain duties, and are subject to its authority. Oh, that's right. The servants are subject to the people's authority, not the other way around, which is what they've done. So, there is a process that is due, depending on who you are. If you're a public servant, there's a little bit of a process that's different. If you're a man in the private, okay, that's a different process. You don't go to the legislature for that. So, to clarify out there for you, Tammy, over on Facebook, that's what I meant by depending on who you are, what the process is, the process that is due. And therefore, the legislature finds and declares, where'd you find this? That it is the policy of this state that the formation of public policy is public business and shall not be conducted in secret. The legislature, not the executive. I agree, everyone needs to learn how to fight back, but you have to know the law first. You have to be properly equipped to go into battle, and you got to be properly trained to go into battle. You're going to get your butt handed to you. You step out on that battlefield and you're not properly equipped and properly trained to defend yourself, you're going to end up dead on the battlefield. Plain and simple. All right. Woohoo. I think my audio might be a little hot tonight. Let's turn that down just a little bit. Not too many crackling out there. All right. So now that we know that the people do not yield their sovereignty to the agency so created by the legislature, okay? So, due process of law, right? We don't yield our sovereignty, God-given rights, okay? So this should say, nothing in the Idaho Code shall be construed as altering our God-given rights. That's what that actually should say. But we'll see here in just a second. What does this say? The next section there? And actually, we got to go to the next one here. The provisions of the Idaho Parental Rights Act are hereby declared to be severable, and if any provision of the Act or the application of such provision to any person or circumstance is declared invalid for any reason, such declaration shall not affect the validity of the remaining portions of the Act. But it's not an act. It's not an act. It's a code. Because if I go look in 2015, so you're saying we didn't actually have these rights until 2015? Give me a frickin' break. So, let's go to the next section here. What did we ever do prior to this Parental Act here, Idaho Parental Rights Act of 2015? Gee, what did we ever do? All right, parental right to the care, custody, and control of their children. Parents have legal custody of any minor child or children, have the fundamental right to make decisions concerning what? Their care, custody, and control. Wait, that's not what we just saw in video, and 99% of the people out there that have experienced this corruption, this evil baby stealing, kidnapping, theft of property. No. We have the fundamental right to make the decisions. Not St. Luke's. Not some nurse working at St. Luke's. Not Child Protective Services or any social worker, which we'll get into. Because this is a fundamental right. This right comes from God, from the laws of nature. It does not come from this statute. It doesn't come from this act in the code. This law pre-existed Idaho, pre-existed any of the colonies. It pre-existed any government ever. Right? That's right here in Genesis 1. Plain and simple. God created mankind. Then we got the right to do the education, which has already been said before, but so why does this need to be reiterated? I don't know. But parents have a legal custody, and it should be lawful custody of their son or daughter, have the fundamental right and duty to make decisions concerning their education, including the right to cause the child to be educated in any manner, authorized under Section 33-202. Now, the government legislature is trying to dictate to us. I thought it was deeply rooted in our nation's history and tradition. I thought it was protected by the 9th Amendment. I thought it was protected by the 13th article of Section 1 of Idaho. But then it even says here, and Section 9, Article 9 of the Constitution of the State of Idaho. Well, let's go look at that one. I'm going to move that over here. We're going to go look at Article 9, Section 9 of the Idaho Constitution. Compulsory attendance at school. That's already on its face void for any effect, because you don't get to compel make it compulsory, right, to compel, the legislature may require by law that every child shall attend the public schools of the state throughout the period between the ages of 6 and 18 years unless educated by other means as provided by law. So, let me show you how the hierarchy works here and what this means. First of all, remember, according to them, the parental rights are protected by the Ninth Amendment. Okay? So that's rights reserved to the states or the people, respectively. It's off limits. We didn't give them that. Oh, but it's in the Constitution. Huh. Well, let me show you something. What is this? A primacy clause, right? This Constitution and the laws of the United States which shall be made in pursuance thereof. So it has to be made pursuant to this Constitution. And if it's not in this Constitution, it wasn't made pursuant to it, and therefore it is void for any effect. And all treaties made, or which shall be made, under, this is the key part, under the authority of the United States, because that's part of this Constitution, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. So, this right here is contrary to the Ninth Amendment. And are what? Deeply rooted in our nation's history and tradition, long before this Idaho Constitution. This is void for any effect because they don't get to dictate to us how we decide to educate our children, whether we even do it or not. That's up to us to decide, not government, ever. So this is void for any effect because it comes in conflict with the supreme law of the land. And it comes in conflict with our rights, our fundamental rights that are long antecedent to the formation of government. See Hale versus Hinkle. All right, then they got to put this in here. Neither the state of Idaho nor any political subdivision thereof may violate a parent's fundamental and established rights protected by this act, and any restriction or interference with such rights shall not be upheld unless it demonstrates by clear and convincing evidence that the restriction or interference is both essential to further a compelling governmental interest and the least restrictive means available for furthering of that compelling governmental interest. Remember that strict scrutiny standard, that test? Okay, it has to be willfully depriving your son or daughter of food or clothing. And again, it's willfully. Not, hey, I'm poor and I can't afford clothes. That's not willful. Then that would be, hey, can we help you out? Sure, but you don't get to take my kids. Helping doesn't mean take my shit. It means help me. Right? So this is part of that governmental compelling interest and that strict scrutiny standard test. The only other thing is physical abuse or sexual abuse. And you have to have the evidence to support the claims. You got to have two witnesses to the same overt act. Because God's law dictates that. So, that's the governmental compelling interest in the strict scrutiny standard test, which actually comes from the common law, which I've showed that from Bouvet's Law Dictionary 1856 under rights and the laws of nature. Those two terms in Bouvet's Law Dictionary. The foregoing principles apply to any interference, whether now existing or hereafter enacted. Nothing. Now, this is it. You'll find this everywhere, right? Nothing in this act shall be construed as invalidating the provisions of the Child Protective Act in Chapter 16, Title 16, Idaho Code, or modify the burden of proof at any stage of proceedings under the Child Protective Act. But I thought you said it was deeply rooted in our nation's history and tradition, that it's protected by the Ninth Amendment, that it's protected by the Due Process Clause. You just subverted your own act. That you admitted these particular rights are fundamental and they're way before this act. Okay? This is the garbage that they're coming in under. Oh, well, this child protected. We got to protect the child, and a rule of procedure says I have the power to act in the best interest of the child. Miranda versus Arizona. Write it down, folks. Miranda versus Arizona. There shall be no rule making or legislation that would abrogate a right. That's what we're looking at right here, right now. That's that rule of procedure that grants them supposed this power over our so-called children. I don't think so. There shall be no rulemaking that would abrogate the right. We don't give you don't get that power over our property. I don't think so. Somebody has to have standing to claim a right to a cause of action and make a demand. And then he can decide to grant relief. But if it requires due process of law, you got to get the consent of a jury. Here we go. Because life, liberty, and property can't be deprived without our own consent or the consent of a jury. Plain and simple. There's no ifs, ands, or buts about this. That's the law. That's what the law says as it is written. That's what it reads. The law of the land. Due process of law. So, but it shouldn't modify the burden of proof at any stage. But see what they said. Oh, it's a what do they call that? The clear and convincing evidence. What's clear and convincing evidence? No, we have beyond a reasonable doubt standard, which requires the consent of all 12 men of a jury. That's the law that dictates that. That would be Virginia Declaration of Rights, June 12, 1776. Before that, it was the Magna Carta of 1215. Clear back to the Aziz of Clarendon, 1166. Right to a trial by a jury. All right. But when you look at that, we'll come back to that here in a second. When a parent's fundamental rights protected by this act are violated, a parent may assert that violation as a claim or defense in a judicial proceeding and may obtain appropriate relief against the governmental entity. Now, they will tell you, well, CPS is, we're part of the government. I got this ID, see here. I'm a social worker, CPS worker, blah, 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 blah. So which way is it? Are you governmental or are you not? Are you a lawfully created agency or are you not? Well, we're a non-governmental agency when they want to use it that way to protect them. Oh, well, we're non-governmental. Then over here, they want to, when they come on your doorstep, they act like that they're, king of the block, and they can just come onto your property and do whatever they want. They don't have to have a warrant, nothing. BS. This is where ignorance of the law. They prey on our ignorance, folks. No, Tammy. That's bullshit. Okay? Here's the problem, folks. This sounds good, but they don't follow any of this. Are you kidding me? No, it's you that has to follow this. You have to hold them responsible. What does it say right there? When a parent's fundamental rights protected by this act are violated, a parent may assert that violation as a claim or defense in a judicial proceeding and may obtain appropriate relief against the governmental entity. When are you going to learn how to do the paperwork and assert your claim and defense? This is the problem in America. Everybody wants to blame somebody else instead of themselves. Take responsibility for your lack of education and frickin' educate yourselves, people. Learn how to effectively defend yourself. It's right here in black and white, and I'm reading it to you right now. A parent may assert that violation as a claim or defense in a judicial proceeding and may obtain appropriate relief against the governmental entity. I'm going to tell you right now, it works. And I'm going to show you right here real quick. Oh my gosh, it's in the rules of procedure. How to do your pleadings and practice. Let's go look at that. Let's just go right here. Family law. Let's go into the family law one. Where is it? Pleadings, right here. Commencement of action, real party, pleadings allowed. Serving and filing of pleadings and other papers. Form of documents and pleadings, general rules of pleadings. Oh, wait, what's that? Counterclaims and cross-claims. I'll be darned. Is that how that's done? That's right. Is it going to let me go to it? All right. The pleading must state as a counterclaim any claim that at the time of the service the pleader has against the opposing party if the claim arises out of the transaction or occurrence to the subject matter of the opposing party's claim, does not require adding another party over whom the claim... Exceptions, the pleader not state the claim if, when the time the action was commenced, the claim was the subject of another pending action, the opposing party... Permissive counterclaim. Pleading may state as a counterclaim against an opposing party any claim that is not compulsory. Relief sought in a counterclaim. A counterclaim need not diminish or defeat the recovery sought by the opposing party. It may request relief that exceeds the amount or differs in kind from the relief sought by the opposing party. Counterclaim against governmental entities. These rules do not expand to the right to assert a counterclaim or claim of credit against the state of Idaho or any political subdivision, agency, or other officer. Aha! Now, let's go back to what it was saying there, because you got to continue to read. If a parent prevails in a civil action against the state or a political subdivision thereof, as provided in subsection 4 of this section, the parent is entitled to reasonable attorney fees and costs. So, this rule of procedure is in conflict with their own Idaho code. But see, you would go to what? You would sue them in an independent action outside of the current case. Okay? But you have to respond to their claims like, oh, well, the mother called in and canceled the appointment and put the child in danger of life, blah, 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 is false. The truth is, I have the right to decide my child's health care, not St. Luke's, not any registered nurse or any kind of nurse or anybody from any kind of a corporation. Okay? And that's the counter claim. They're claiming they have this authority. You counter that with saying that's not true. That's false. In fact, the truth is, and you cite your right. Because the claim and exercise of a right cannot be converted into a crime. And when you assert the right stands on the higher plane than a statute. Because that's law versus policy. And again, Miranda versus Arizona. You have to do the paperwork, folks. There is no ifs, ands, or buts about it. Same thing with Ammon Bundy. Oh, I'm not going to participate. Dude, you were given notice. You have a duty to respond. Let me show you where that's at. Just under the general civil rules, okay? Because like Ammon Bundy stuff, that they went in under civil, right? Now, we do motions to dismiss. Right, that's right there. Defenses and objections. When and how presented. Motion for judgment on the pleadings. Consolidated motion, waiving defenses, hearing before trial. Okay? That's that Rule 12b-6 sometimes that they'll refer to. You know, that's the one that they do when we go to sue them in federal court. They automatically do a motion 12b-6, motion to dismiss. Think about this. Why is it that that is the first thing that they file when we go to sue them? Why are we not doing the same thing when they go to sue us? Why are we not doing a motion to dismiss? Imagine that. Counterclaims and cross-claims. Here it is again. That's because it's all part of the rules of civil procedure, right? This is how this works. This is the game of tennis. You got to hit the ball back. You have to respond. If you don't hit the ball back after being served the ball in a game of tennis, and it's so the ball is in your court, and you don't hit the ball back, that's a point for them. And they can move for default judgment. Let's see, where is that? There's a good one in here that you really need to pay attention to. Request for discovery. Depositions, interrogatories. Oh my gosh. When a demand is made for a trial by jury, right to jury preserved, demand for jury. See, they've switched it around on us. You have to request it. Even though it'll say in here that in order to waive the right to a trial by jury, they have this form, you got to fill this form out, and then you waive your right to a trial by jury. Wait a minute. I could see that. Fill the form out to waive your right to a trial by jury. Otherwise, it has to be a trial by jury. That's the only way it can be done. This crap about a trial by the court, no, I don't think so. That's not due process of law, and that's not how the right to a trial by jury works. Where is it? Facts of general subpoenas. Did I miss it? And there's your default judgment, entering a default judgment. Okay. I guess I went right over it. Constitutionality challenge and notice of fraud. Conditions of mind. Oh, this is where you could really hammer them, folks, because remember these two maxims of law. Ignorance of the law is no excuse. Number two, to know a thing and to be bound to know it are regarded in law as equivalent. If they're claiming that they're from CPS and they got their little fancy badge, and then the officers that come with them, they better damn well have an oath of office. Okay? So they're already bound to know. That's Article 6, Clause 3. Oh, no, yeah, I guess it is right here. Rule number 9. What does that say? Violation of rights and fraud. Fraud or mistake, conditions of mind, violation of rights. In alleging fraud or mistake or a violation of civil or constitutional rights, a party must state with particularity the circumstances constituting the fraud or mistake or the violation of civil or constitutional rights. Malice, intent, knowledge, and other conditions of a person's mind may be alleged generally. You picking that up, folks? Remember, the first fundamental principle of due process of law is notice and opportunity to respond. This is giving notice right here, right back to, what does it say right here? When a parent's fundamental rights protected by this act are violated, a parent may assert that violation as a claim or defense in a judicial proceeding and may obtain appropriate relief against the governmental entity. You're right. Again, Tammy. Most people don't know all of this. Ignorance of the law is no excuse. You can't claim you don't know. It doesn't work. Try that. Try going into court and say, I just don't know. Sucks to be you. The other side is taking action against you. And you have a duty to respond. You don't respond, well, the judge has to assume the presumptions in the record are true. Right? They make their claims. Those are the presumptions in the record. And if they don't end up being rebutted, counterclaimed, the judge has to assume that it's true because the record is deficient of any rebuttal, of any challenge, of any affirmative defenses or objections. Okay? So, who is responsible for our own education? We are. Not the government, not the public schools. This crap about, they should have taught this in public schools. No. No. Our mother and father should have taught us this stuff. But this is the dumbing down of America. Back to the Rules for Radicals written by Saul Alinsky. Hello? Take over the education. So, again, follow the rules of procedure and allege that these people are insane. They're not of sound mind because the law dictates you have these rights. They have no right to do what they did. Right? And then this is where you put them on notice. Right? We come over here to 18 USC subsection what? Come on, people. A lot of people know these ones. A lot of people throw these around. 241 and 242, right? They call civil rights. These are natural rights, God-given rights, but I would claim them as such. But that's a conspiracy against rights, and it's also a deprivation of rights under color of law, because this is all color of law. All of this right here is all color of law. It's not law. Because look at what it says. Read it. whoever, under color of any law, statute, ordinance, regulation, or custom, that's all color of law. Statutes are color of law. Ordinances are color of law. Regulations are color of law. Even a custom is color of law. Willfully subjects any person in any state, territory, commonwealth, possession, district, or deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such person being in. This is the or. So we'll just stop right there. Okay? Shall be fined under this title or imprisoned not more than 1 year or both. And if bodily injury results from the acts committed in the violation of this section, or such acts include the use, attempted use, or threatened use of dangerous weapon, oh, that's right. It becomes aggravated when they do this with arms. So when they have a police officer standing there with arms on, that's what that's talking about. They don't even have to point them at you. They don't even have to pull them. Just the mere presence constitutes aggravated. Okay, but read on what it says here. Threatened use of dangerous weapons, explosive, or fire shall be fined and assigned in prison not more than 10 years, or both. And if death results from the acts committed violates the section, such acts include what? Kidnapping or an attempt to kidnap. Aggravated sexual abuse or attempt to commit aggravated sexual abuse or attempt to kill shall be fined in this title or imprisoned for any term of years or for life or both, or may be sentenced to death. This is what you'd put in your little lawful notification letter to the CPS worker, the police officer, to the judge, everybody who conspires together under this color of law. And you demand your property be returned to you. Not your child. That's my property. Okay? That's how serious this is. Now, when you want to conspire, here we go. If 2 or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, territory, possession, district, free exercise, or enjoyment of any right or privilege secured to him by the constitutional laws of the United States, or because of having so exercised the same, if 2 or more persons go in disguise on the highway. See, take off all the clothes, the disguise. We're either man or woman. For those of you that are familiar with, men and women body parts, you know the difference here. That's that clothed with authority, like the Hobbs Act. That's those 2 or more persons. So you got like the CPS worker and a police officer. That's 2 or more. Or on the premises of another, like when they come to your house, with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured. Don't let him tell you that. And again, put this stuff in writing. Everything is done on paper. You cannot talk about something on the record that is not in the court of record. You have to give proper notice and afford them the opportunity to respond. Now, after you've put the court on notice, that court of record, the paperwork, then you got them, and then you can talk about, then you can assert what you put in there and make your demands that you already demanded in your motion to dismiss. Because that's under the prayer for relief as part of a motion. Motion is in part, how you do your demands. your demand for relief. So, when you do that, everybody's put on notice. Now, I want to remind people, I've said this many times over the years. You have to keep calm, keep your cool, because that's what they want us to do. They want us to get all frustrated. They want us to get all freaked out and yell and scream at them, and so they can point fingers and say, oh yeah, look how crazy they are. I get, and this is part of the reason why I left the whole family law realm of things, is because people, generally speaking, are so mentally, psychologically traumatized, they just can't do this. They can't function. They just can't keep their wits about them because of the psychological trauma. And I get it. But it does me no good to try and help people that can't help themselves. Because I can't do it for you. You're going to have to do it. So you're going to have to learn to be strong. Pray to God for strength and courage. Put on the full armor of God when you go into battle. God will give you what needs to be said within the hour. Okay? But let's read this here. The other part of that is the first court that we go into is the de facto kangaroo court. It is by evil design to deny. What you have to keep in your mind is that I put all of you on notice. I'm affording you the opportunity to do the right thing. And if you deny justice here, Judge, you become culpable. You're conspiring against these rights after notice. So this goes back to due process of law that is due to the judge going to the legislature, but you got to have your court of record as evidence for them to look at to prove that you put them on notice, that you afforded them the opportunity to do the right thing, and they didn't. You don't get to just talk about it. It has to be done in writing. I cannot stress this enough. But stay calm, keep your cool, because that's the game that they will play. But I can tell you right now, in my personal experience and taking this knowledge that I have and sharing it with them and using it, I've had people get their kids back in 2 days. 1 day. Okay? It's all about putting them on notice. Doing the proper paperwork. Following the rules of procedure. Pleadings and practice, which actually comes from the common law. Okay? So, what does it say? If two or more persons go in disguise on a highway or on the premise of another with intent to prevent or hinder the free exercise and enjoyment of any right or privilege so secured, shall be fined, and guess what? Same damn thing. If it involves attempt to kidnap, kidnapping or attempt to kidnap, just an attempt, like in the video, we're going to take your kid. That's the attempt right there. Then when they actually did it, every last one of them in the video that stood around, they are all conspired. They all could be sentenced to death if these people knew their rights, that they exerted their rights in court in the paperwork, put the court on notice and said these guys were in the wrong. They had no lawful authority to kidnap my son, in this instance, and theft of my property. I want my property back now. Because they didn't follow due process of law. Oh, would that be one of them rights that happens to be enumerated here? And you put them on notice. And when you file your criminal complaint, you got to put your notice in there that you're seeking the death penalty. That'll get their attention real frickin' quick. No doubt about it. So this, This stuff's in writing. There is no excuse for not reading this and knowing this. None. Absolutely zero excuse. I don't buy any excuse. None. You know, excuses are like a-holes. Everybody's got one and they all stink. That's a fact. Kind of makes you wonder why dogs come up and sniff your crotch all the time. I don't know. So it's up to us to educate ourselves, and I'm out here doing this for free for years. I've got the educational series. I've gone way more in depth in the 2-hour video in the educational series on this particular subject. But again, I don't want to say which episode it is because people need to watch them all because they all go together in a chronological order of things from start to finish. With the addition on YouTube, the addition of the other 3 videos now. 2 of them on the laws of nature. Now, again, I'll point this out again. Idaho, right? Rules of evidence. Judicial knowledge. Facts judicially noticed. So you have to do a judicial notice. What does that say? The laws of nature. Imagine that, folks. Just for a second, imagine knowing what the laws of nature are. That's right. Comes from God, the law prescribed by God, the sovereign of the universe. These are those natural God-given rights, not civil rights. Civil is the trickery, thinking that we have civil rights. No, we have natural rights and we have political rights. Those civil comes from the Roman civil law, and they consider them more like privileges, not rights. Which is why we have things like this. The Parental Rights Act. Oh, we're so good. We made an act about parental rights in 2015 as if we didn't have these rights already. Just exactly what the heck are these people doing in the legislature thinking that they have the authority to even make this stuff? It's not needed. All of this stuff is supposed to be self-evident. That's right. Right on my YouTube channel, folks. Educational series. Take you right over there right now. Let's just see. Where's my channel? How do I get to it? Oh, I got this thing in the way. Alright, so go right over here where it says playlists. Oh, let's see. Educational series right there. There's episode 1 of 8. Take all right into here, and then you got the right to... Oh, yeah, I guess... Oh, I can remember putting that one in there, but I guess, okay, Great State, the Rise, that must be one I put in there. But the ones I was talking about was the right to petition the legislature for the redress of grievances. That's that Article 1, Section 2, and Article 1, Section 10 of our rights. And then Declaration of Independence and the Laws of Nature, Part 1 and Part 2. Okay? So, they're all right around 2 hours. So, of the 8, You got roughly 16, maybe 17 hours total of free education that you can pick up and learn from here. You don't need me. You don't need to talk to me. Nothing. That's all right there. Okay? And for the most part, I direct people to these first before I even begin to talk to somebody, because there is no reason for me to talk to you about what I've already put out here for free that you can watch on your own time without needing me to be present. There is no excuse for not coming and watching these. None. Other than you just don't want to. But that's not really an excuse. You don't have to learn from me. You can do what you want. But I've done this to try and educate my fellow man and do the best that I can at the time when I put these out. Trust me, I've gained quite a bit of knowledge even since doing these. This is, 3 years ago? Yeah, a little over 3 years ago. This one's got close to 25,000 views on it. October 1st, 2019 is when I uploaded it over here. So, there you go, folks. It's up to you. I can only lead the horse to the water. It's up to you to drink the water. I agree. It's pretty sad. We're in a pretty sad state of affair where the people allow the public servants to be as corrupt as they are. Because, again, all political power is inherent in the people. We have the right to alter, reform, or abolish anything at any time we deem it necessary. At any time. So when are the people going to get off their lazy asses and start abolishing? When are they going to start claiming and exercising their rights? Following due process of law. What's your excuse? And again, I can't do this by myself. Need the people to come forth. I mean, I can do some little stuff, effectively defending myself and trying to take down some stuff that I can. But when it comes to, let's say, taking down CPS, let's do a petition to the legislature to abolish CPS. Do you realize how many people it would take to do that? The other thing we could do is our own initiative in every single state, which would be to abolish the CPS agency and anything to do with any of that, right? We could abolish that. But it would take a majority of the people to do that. That's right. It would take a certain amount of signatures to even get it on the ballot. And then put it to a vote at the next election to abolish CPS. To abolish the Juvenile Protection Act. We can do that. We have every right to do that. All political power is inherent in the people. At any time we can do that. And again, I'm going to, time. I didn't even get to Hardwick versus Vreeken. Where basically it says you got to have a warrant. You can't just arbitrarily take kids. There's one thing that they can do, and that's if the child is in imminent danger, there's an emergency circumstances. If I don't take that child right now, and I spend the time to go to the court to get a warrant, to seize the child, and by the time I get back with the warrant, the child will be dead. That's it. So therefore, that's one of the challenges, right? Are they of sound mind? Was the child in any kind of agency? Was the child in loss of life or limb? Uh-oh. Where's the evidence to support that claim? There isn't any. We just arbitrarily did what we did. Busted. That's your counterclaim. That's your cross claim. The cross claim is you're claiming that they conspired to deprive your rights. And they kidnapped, right? Use the verbiage in there at the time when you're going after them. And watch how fast they all backpedal and drop the case and give you your kids back. But if you do this paperwork right in the very beginning, just like what they did there, they ended up hiring an attorney, member of the bar, which is pretty rare that they would do that. But when you have that many people standing behind you, 50 to 100 people, that show up for court and stare down the judge and the CPS workers, let me tell you, the fear of God gets into them because now there's a lot of people watching. So that's one of the other drawbacks or advantages for those that can get a group of people to come show up to court. Even when they tell, you can't go in there, these people can't come into the court hearing. Just knowing that the people are out there. Okay? They hired an attorney and they were able to get their kids back within 2 weeks there? And actually the child's health actually declined while in their custody. Hardwick versus Vreeken. And I'm just going to go skip right down to my most favorite part. I just love this. It's on page 10. Come on. How about right here? Parents and children have a well-elaborated constitutional right to live together without governmental interference. Bam. That right is an essential liberty interest. Okay, that would be a liberty interest. Protected by the 14th Amendment. No. Try again. Ninth. Guarantee that parents and children will not be separated by the state without due process of law except in an emergency. That's Wallace versus Spencer, 9th Circuit in 2000. Citations omitted. You would want to go get that case. I should go get it, put it together. But Hardwick versus Vreeken. Over the years, Supreme Court has recognized this fundamental right in many cases. For example, Cleveland Board of Education versus LaFleur. The court said this court has long recognized the freedom of personal choice in matters of marriage and family life is one of the liberties protected by due process clause of the... They keep saying 14th. It's not 14th. It's 5th. 5th Amendment. 14th Amendment didn't exist. The court reiterated this theme 3 years later. Decision established that the Constitution protects the sanctity of the family precisely because the institution of the family is deeply rooted in this nation's history and tradition. Whoa, wait a minute. Not exactly what it says there in the Idaho Code. Except for they don't cite the 14th Amendment. They cite the 9th Amendment and the 13th article of Article 1, clause of Article 1 of our Declaration of Rights here in Idaho. It is through the family that we inculcate and pass down down many of our most cherished values, moral, and culture. The defendants do not contend, nor could they, that Presley did not have a constitutional due process right or a Fourth Amendment right protecting her against deliberate government use of perjured testimony and fabricated evidence in the dependency court proceeding designed to rupture her familial relationship with her mother. This right is beyond debate. What they do claim is that the specific granular right to be free from deliberately fabricated evidence in civil child dependency proceedings where a parent or child's protected familial liberty interest is at stake had not yet been clearly established prior to the dependency proceeding at issue. Oh, well, but it doesn't say, we don't have a court case that doesn't tell us that we can't lie. If you ever watched the video on this case when it was being presented in the appellate, they can see that the rights of Presley relies upon had been clearly established in criminal proceeding against parents, but not yet in a civil proceeding context. That's because it's supposed to be criminal in nature, that you willfully deprive the child of food or clothing, or that you willfully physically abuse the child. And I'm not talking about spankings or paddlings or what have we. We're talking about serious, bruises and marks and broken bones and that kind of stuff. There's a clear distinction between child physical abuse and correcting them. Discipline. But even then, they disagreed. Clearly established. An official cannot be said to have violated a clearly established right unless the right's contours were sufficiently definite that any reasonable official in his or her shoes would have understood that he or she was violating it. This stuff is supposed to be common sense, self-evident stuff, right? Which is what we're going to get into here. I just love this, what the judge had to say here. Right here, and I believe it is page 10, right? Or was it 14? 13 starts on 13. Yeah, okay. Starts on 13 at the end of 13 and goes to page 14. No official with an IQ greater than room temperature in Alaska. How you doing up there, Cece? What's the temperature up there in Alaska? What's the room temperature? Could claim that he or she did not know that the conduct at the center of this case violated both state and federal law. The social workers in this case are alleged to have knowingly and maliciously violated the law in their attempt to sever Presley's protected relationship with her mother. Perjury is a crime under both federal and California state law, as is the knowing submission of false evidence to a court. What do they cite there? 18 U.S.C. 1621. Both crimes make no distinction between criminal and civil proceedings. This malicious criminal behavior is hardly conduct for which qualified immunity is either justified or appropriate. The doctrine exists to protect mistaken but reasonable decisions, not purposeful criminal conduct. As the Supreme Court repeated in the Sheehan case, officials who knowingly violate the law are not entitled to immunity. We picking it up? Okay. Anybody with an IQ greater than 78, which you're pretty freaking dumb at 78 if you got an IQ that low, and I apologize if you do, but you're probably not understanding any of this with an IQ of 78. You can't claim you don't know. Absolutely, you can totally use this case. This is one of our Supreme Court landmark cases that took 17 and a half years for them to come out and say, you can't lie to deprive fundamental rights. Oh my gosh, are you frickin' kidding me? Which is why I love this part. Any official with an IQ greater than room temperature in Alaska, no official with an IQ greater than room temperature in Alaska could claim that he or she did not know that the conduct at the center of this case violated both state and federal law, including the judge. Any official. Over here on Telegram, court-like appearance, because it's not Article 3 court. I could care less what court you want to call it. The court is the paperwork. Venue is not jurisdiction. Your paperwork is the court of record. Okay? Y'all need to learn that. And an Article 3 court, let's just go ahead and I don't get why people say Article 3, Article 3, Article 3. Because Article 3 courts are admiralty and maritime jurisdiction courts. Do you folks even frickin' read? What is wrong with people? You act like you know something and you don't. You didn't even read it. Article 3. What does it say? The judicial power of the United States shall be vested in one Supreme Court and such inferior courts as the Congress may from time to time ordain. So the judicial power here, that's here, right here. If it ain't here, it ain't there. The judicial power shall extend to all cases in law and equity. Not suits at law. These are suits in law. Incorporated into the body politic. Under what? Arising under this Constitution, the laws of the United States and treaties made which shall be made under their authority to all cases affecting ambassadors, other public ministers and consuls, to all cases of what? Admiralty and maritime jurisdiction. I don't see any other jurisdiction here. None. To controversies to which the United States shall be a party. To controversies between two or more states. Between a state and the citizens of another state. Between citizens of different states. Between citizens of the same state claiming lands under grants of different states and between a state. Or of citizens. That's that equitable interest in land. I don't know, in all cases affecting ambassadors or public ministers and consuls, and those in which a state shall be a party. Where in the heck does it say man? No, suits between man and man are suits at common law. Not suits in law and in equity involving an equitable interest in land. And I just totally destroy the argument of, oh, well, we can use the law of equity. No, no, no. The maxim of law is you may resort to the law of equity if the common law does not provide the remedy and relief. Common law comes first. And it's the law of equity may be resorted to where the common law is deficient. So, again, the common law comes first. The trial of all crimes, except in cases of impeachment, shall be by jury. Such trials shall be held in the state where the said crime shall have been committed, but when not committed within any state, the trial shall be at such place or place of Congress may by law have directed. So, wait a minute, what are we talking about? Except in cases of impeachment? The people don't get impeached. No. No, 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 no. We don't want Article 3 courts. What we do want is Article 7 courts. Our common law courts. Suits between man and man. Because government doesn't have personal jurisdiction over man. We're not bound by the Constitution, therefore it's not under the Constitution. And nothing under the Constitution applies to the people. That's this right here. The people of the state of Idaho, creating the instruments of government that serve them, do not yield their sovereignty to the agencies co-created. There is no personal jurisdiction over man. That's per the laws of nature, the law of nations. Book 1, Preliminaries of Law of Nations. And I'll be darned, right here, Article 1, Section 1. Inalienable rights of man, which are actually unalienable rights of man. All men are by nature free and equal and have certain inalienable rights, among which are what? Enjoying and defending life and liberty, acquiring, possessing, and protecting property, pursuing happiness and securing safety. These are rights of man, not persons. And see, the government can't bring a suit at common law. They can only go after persons, that which is created by them under the authority delegated by the people. But this is the trickery, right? They try to tell us that, oh, well, that's for civil cases. And that you know, for anything over $20, you still have the right to a trial by jury. Now, see, suits at common law can be criminal in nature or civil in nature. It's about in nature, which is why we have the right to demand the cause and nature, or the nature and cause of action. What's the nature here? Is this criminal in nature? Because that evokes what type of jury. If it's criminal in nature, then it's beyond a reasonable doubt. You got to get consent from all 12. If there's one of them that's not quite convinced and they don't give their consent, that is an acquittal, not a hung jury. There's no such thing as a hung jury. You either get unanimous consent from all 12 or you lose. You have to convince them. That's the beyond a reasonable doubt standard. Which is where that clear and convincing evidence comes from. No. That's the shmew. That's where hearsay and all that stuff comes in. Okay? The next part is if it's civil in nature, where it was an accident. Right? There's no way that I can prove my neighbor, willfully, with malice, wrecked into my fence. Caused damage to my fence. It was an accident. That's civil. And I can only get the damage that he caused to my fence. And that's it. That's all I'm entitled to. Actual damages. No punitive damages in civil. Punitive damages are for willfulness, criminal in nature. But what does it say? In suits at common law, not suits in law. Where the value and controversy shall exceed $20, the right to a trial by jury shall be preserved. And no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. That means the common law courts are not courts of the United States. They are not Article 3 courts. And it can't be heard in any courts of the United States until after it's been heard in a common law court pursuant to the rules of the common law. And even on appeal to a court of the United States, they still have to do it pursuant to the rules of the common law. Because the law says so. Not because of my opinion or what I think. That's what it says as it is written. Now you're either of sound mind, possessed in logic and reason, and shall come to a reasonable conclusion based in reality that our common law courts are not courts of the United States, they're the people's courts, or you are insane. And per the laws of nature, we are to shun the insane. We go so far as, in insane asylums, and we lock people up for that. That's your two choices. You're either of sound mind or you are insane. Just like you got two choices. There's man and man with a womb. Womb man. That's your only two choices. You're either of sound mind or you are insane. All right, folks. Well, that's the problem. They got rid of our common law courts with the Reconstruction Acts of 1871. When are the people going to reassemble government de jure and take back our power? Right? I'll put the joke out there. Whoa, man. God created Whoa, man. Gave us a warning label. Whoa, man. Can't say that God didn't warn us. Who is the judge of that same mind? Facts are. Reality is. Like 2 + 2 = 4. Any man out there or woman who wants to think that 2 + 2 = something other than 4, everybody who knows mathematics, the rules of mathematics or the principles of mathematics that dictate that is the correct answer is 4. Everybody who knows the principles and rule of law, rule of mathematics, when somebody says, well, no, 2 + 2 = 5, we all know that they're insane. It's self-evident. That's the key. See, and that's the thing. Positive law, that's all part of that Roman civil law crap, right? We're supposed to be living over here under God's law. Free and independent. Per the laws of nature, per the law of nations. Right? We're supposed to be completely free from government. Anything created by our fellow man. Unless we give our own consent. Plain and simple, none of this stuff applies. Are you bound by the Constitution? Then the Constitution doesn't apply to you. And anything created under this Constitution doesn't apply unless you're bound by it. You got to be a member of the club in order for the club rules to apply. Well, Tammy out on Facebook. Alrighty then, but these fools lie so much. Any official with an IQ greater than room temperature in Alaska, call him out on it. That is not true. That's a counterclaim. So-and-so makes this claim, whatever it is they say, that's how you write it out, is false. In fact, the truth is, you're countering their claim. Bam. Now, there is a controversy before the court. And when you counter their claims and say, no, 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 that's not true, I'm going to demand strict proof in accordance with the strict standard of rules of evidence, that shifts the burden on them to produce the evidence to support their claims. And let me tell you from personal experience, when going to court and doing this, it's so great. It's a great feeling. Because when you get them on the stand, because they have to get on the stand to testify, the moving party, right? And you get to cross-examine them. Oh, this is the fun stuff. And you start asking them questions like, well, you said over here, did you submit any evidence here today to support this claim? No. Oh, you didn't? So you committed perjury. Did you submit any evidence here today to support this claim? Did you submit any evidence here to support this claim? That you signed all this under penalty of perjury when you started this case, right? That's your signature down here on the bottom under penalty of perjury, right? Here in Idaho, that carries 1 to 14 years prison time. That's a felony. Where's your evidence to support your claims? Oh, you didn't submit any of that. You're going to prison. You have to learn to play the game of tennis, because that's exactly what the court is. Think about it. There's two parts to the court. There's the plaintiff and the defendant, the moving party, the defender, the attorney, the lawyer. Pardon me. Should do the other. Anyways. Prosecuting attorney and defense lawyer, which has nothing to do with the member of the bar. Okay, we all have the right to prosecute our own claims, and we all have the right to defend our own case, whatever it is, the claims made against us. So, one is a prosecuting attorney, to take from one man and give to another. If you have standing in a cause of action, you have the right to attorn your fellow man. If my neighbor wrecks into my fence, I have every right to attorn him, be the prosecuting attorney, and prosecute him for my claims for the damages he caused to my fence. Now that I've named him as the primary named defendant, he has the right to what? Act as a defense lawyer. One who is knowledgeable on the law, one who speaks the law, is a law sayer. Has nothing to do with the bar. That would be where I found that one. Wisconsin Constitution, Article 1, Section 21. Rights of suitors, the right to prosecute our own claims. Prosecuting attorney. That's right. Why do they call it a durable power of attorney? In fact. So the tennis court. You got a court split in half with that net up there, right? Where's the judge? The referee sits on the outside of the court observing, watching the ball go back and forth. And the only time he speaks up is when there's an objection. Demand for relief. Got to make a ruling. That's the only time that man should be speaking. Otherwise, it's you or the other side. All done on paper. There's no real reason to even speak much inside the courtroom. Should all be done on paper. And anytime you do have a court hearing, you should be making short, clear, concise statements of facts. And that's it. And I mean short. Because everything's supposed to be done on paper. Like, hey, on such and such day, I served them with a motion to dismiss. On such and such day, I served them with a brief memorandum of law in support of the motion to dismiss. It is now such and such date, and they have failed to respond with an objection to the motion to dismiss. That is grounds for default judgment. Judge, I demand a default judgment. It's that quick and simple. If there's no objection to your motion, that gets entered by default. Now let's say there is an objection, doesn't matter. It's got to go by the sufficiency of the record. What's on paper. The court of record. The court is the paperwork. not the venue. Venue is not jurisdiction. Paperwork is. Everything is done on paper. And then the beauty of all this is you're creating the record. And this is what you use as evidence against them. One, that you gave them notice and afforded them the opportunity to do the right thing, the just thing. It's documented. Number two, their responses, their BS arguments, their color of law that they try to assert higher than our rights, which doesn't work. Any man of a, what? Any official with an IQ greater than room temperature in Alaska? Yeah, that whole thing. So from there, when you go to file your criminal complaint, like Form A091, with the Federal District Building Executive Branch, not Judicial Branch, Executive Branch, and your Title 42, 1983 civil lawsuit, and I'll go with, again, we'll start with the Chadman's one that Rob found. My brother Rob out here found that, and we've got he got one of those books sitting up at the office, Chadman's Encyclopedia, and it says you have to do the criminal prosecution first before you can do the civil, because criminal is where you get the punitive damages. You can't get punitive damages in a civil case. Punitive comes from the criminal process, not the civil. Civil's for actual damages. The actual damages to the fence. Okay? And to back this up, I always refer to the O.J. Simpson trials. Who's old enough to remember those? What did they have to do first? Didn't they have to do the criminal trial first? And then he was acquitted. So they weren't able to lay claim to the punitive damages in the civil case. Remember that? Remember that? You have to do the criminal first in order to get the punitive damages. You can't get punitive damages in a civil case. You gotta have the criminal first. They gotta be convicted. Okay. Ooh, little past tonight, but hey, well worth it. All right, folks. One little tidbit here. For those of you who'd like to give a little support here, we'll go over here to my fancy website, kirkslawcorner.com. See that? kirkslawcorner.com. Okay. Now you go up here and you go to the links tab here. This will get you to my Rumble channel, my Facebook channel, and my Telegram channel. Okay, those are links to everywhere aside from YouTube, which I didn't put YouTube on there because I pretty much thought I was done over there on YouTube. I'm not really doing anything with this right now on Telegram on Friday nights for the KLC American Patriots main channel, but that's where we're working on trying to educate the people on to assemble, but I'll get to that here in just a second. Now I come over here to the library tab. All sorts of goodies here. Okay? And this is in a chronological order of things. I've made this about as simple and as easy as I can for you. Okay? This is a good place to start reading to learn the basics of the American common law and the law of nations, or the principles of the law of nature as international law. So you start here with the Treatise on Arrest and False Imprisonment by Charles Wiseman. The Authority of Law by Charles Wiseman. This is about the legislative branch and what a real statute looks like and how it has to be created lawfully. Then here's your law of nations, or the principles of the law of nature applied to the conduct and affairs of nations and sovereigns, with 3 early essays on the origin and nature of natural law and on luxury. Hardcore, serious education information right there. Okay, as applied to the conduct and affairs of nations and sovereigns. Yeah, it applies to them, to government. It's a limitation, period. Remember that? Judicial notice? Oh, I guess I already, well, right here. Judicial notice, the laws of nature. Oh, I guess that would be that, wouldn't it? And then the report of the Commission on Unalienable Rights. I'll be darned, that's a good one. I still have yet to read all of that. Then once you get through all of that, then you go into the common law. You know, so many people keep asking about this common law stuff. Well, here it is. Treatise on Arrest and False Imprisonment, heavy on the common law. The authority of law, heavy on the common law. The report of the Commission on Unalienable Rights, heavy on the common law. The law of nations, international law, still heavy on the common law. Elements of the Law and Practice of Legislative Assemblies in the United States of America by Luther Stearns Cushions. This is what? Let me say that again. Elements of the law and practice of legislative assemblies in the United States of America. That's right. This is the common law and practice, because that's where that came from. That's where the practice comes from, is the common law. The common law is the real law. It doesn't come from the statutes. Then here's this Mason's Manual Legislative Procedure. This is the 2010 edition. Okay? This sucker here references this book over here, Lex Parliamentaria Americana, and says Cushion damn near every single page of this book. Sometimes 2 to 3, 5 times on a small page with big writing. Real easy reading. Another one of those 2 places that cites the right of the people to petition the legislature, the right to the petitioners to present their own petitions. So this debunks this rulemaking that they do in their rules of procedure for the House and the Senate, saying, petitions can only be presented by the representatives. No, the law, our rights, dictate we have the right to present our own petitions. We don't seek permission from our servants to exercise the right. Sit down, shut up, and do what you're told, servants. We're the masters here. And it's time to start acting like it, people. Okay? This is this is Jefferson's Manual on Parliamentary Practice. Jefferson's Manual. And then here's a 1953 edition by Paul Mason. Still the Mason's Manual by Paul Mason. This is the 1953 Mason's Manual Legislative Procedure. There's been some changes in between there, but in reality, Mason's Manual Legislative Procedure is a subversion of Lex Parliamentaria Americana. This is the law and practice. This is a subversion. Then you want to learn about the Constitution. First, you should read the damn thing, but that would really help. The whole thing, all of it, word for word, fully comprehend what it says as it is written. Number 2, then you get into the commentaries on the Constitution of the United States with preliminary review by Joseph Story. And then you can get into things like, which he references in here many times throughout these 3 different volumes, the Federalist Paper. Then you want to look at the anti-Federalist papers to get even more insight. So, the thing is, reading means reading. And you cannot blame anybody else for your lack of knowledge but yourself. Bouvet's Law Dictionary, 1856, right here. That's the first one here. Black's Law Dictionary, 4th edition. And then Maxims of Law. Solid stuff. And any you can pull out of the Bible, the better. Rule of law, maxims of law. It's a rule of law. It rules over law, like the rule of mathematics, like the plus sign, the minus sign, the multiplication sign, the division sign. Those are the rules or principles of mathematics that dictate the correct answer. Completely irrelevant of your personal feelings, what you think 2 + 2 equals. The rule of law, rule of mathematics dictate the correct answer every time. And that's how we know the difference between a man who is of sound mind, possessing logic and reason, who has the ability to come to a reasonable conclusion based in reality, or they are insane. Mathematics is actually logic. Very logical. What? Tony Pellegrino, where's he at? Somebody see him somewhere. Huh. Anyway. There you go. Hey, brother. Brother Tony Pellegrino out there trying to do a remonstrance in California against a bill out there. Should give me a call here. I'll be off air here in just a couple minutes. So anyway, there's some good reading stuff for you folks to get a head start. You know, educational series. You can get to it from right here too. Furthermore, right here are these little hyperlinks to my Facebook, my Telegram. Now, Patreon. That's where you want to get in on Wednesday night workshop, or if you'd like to help support me, just donate. You know, Tier 1, Tier 2, $5 or $10 a month. Okay. This does get you to the YouTube channel and my Rumble channel. So pretty much the same links that's over here in the links tab right there on the home screen. Now I don't want to click on the Patreon because it'll log me in as the administrator and it's totally different from what it would look like for anybody else going on there. So, other than that, Tier 3 is Wednesday night workshop, and Tier 4 is for the one-on-ones. If you'd like to have one-on-one time with me, that's where it's at. That's how to get a hold of me there. And then once you join there, go on to the channel Patreon there, and there's a post on there to go to Calendly to set up one-on-ones. And this one right here will get you right directly to episode 1 of the educational series. You can just click on that and click on the YouTube thing here. It'll take you right to it. Other than that, for any kind of other kinds of donations, you know, cash wrapped aluminum foil, money orders, postal money orders, cashier's checks, again, cash wrapped in aluminum foil, send it over here to the office in the snail mail. Gold and silver coinage, any law books. That's I probably should do a wish list, but I've gotten a few, so. Now, the last thing that I'd like to touch on, Thursday nights, National Assembly, and that's national-assembly.net. Here's the conference call info. Every Thursday night, there's the business portion, and then we have the part of the second session of that. of that call turns into the general discussion, usually educational thing, some Q&A and that kind of stuff. You can actually download and install free conference call. It's free. That's you can download that on your smartphone from for Apple's iPhones for both of those platforms. Android. Got a lot going through here. Here's a tutorial video for smartphones if you want to learn how to do that on your phone. Tutorial for desktop computer app here. You can actually download and install the app on your desktop computer. So you can put it on your phones as an app, or you can just dial directly. I highly recommend getting the app. It's so much simpler to use than trying to just dial in. But there are people out there that don't have internet, that don't do it that way. All they have is their phone and a phone call. Flip phones. Actually, I know somebody who has a flip phone who doesn't really do the internet at all. So this is where we're trying to bring the people together to reassemble government de jure. Okay? And that is the General Assembly. I don't know if Michelle speaks highly of it or not. I know that she didn't. She didn't want to do it back in the day when I turned her on to it. Oh, no, I'm not doing that because, yeah. Now all of a sudden a change of tune over there, I guess. I don't know. But now there's some resources here. You can watch some of the assembly supporting videos, 10 steps to an assembly. Here's that training manual, TM 2025, that Oscar and I went over here not too long ago. Oscar's been going over it on the assembly calls on Thursday nights. Should be close to wrapping that up. I think he's been doing each section one by one. One a week, right? Trying to get through those. But and then his Hardline podcast, Jason from his Hardline, him and I did a couple of videos together. Great stuff. Good guy over there. Both Oscar and Jason. Good guys. In the fight, just right along with me, you know. But that's it. And of course, you know, you want to learn about the state national fraud. That would be me. That's right. I break it all down, including the etymology, the origin of words, as in national didn't even exist until 1887. Yeah. Go ahead and change your status to a national under the corporation that's defunct to begin with. Because that's what it is, the term national, from the United States Code, which is the corporate bylaws of the United States, Inc., means a person owing permanent allegiance to a state. Oh, well, that would be a citizen. The term national United States means a citizen of the United States. Oh, that's a member of the corporation. Because that's what a citizen is defined as, right? Again, Law of Nations, Book 1, Chapter 19, Subsection 212, Citizens and Natives. The citizens are the members of the civil society who are bound to this society by certain duties and subject to its authority. They equally participate in its advantages, those emoluments, any advantage, profits, or gains. Like a paycheck for being the president, that's a member, because that's, again, right here. Article 6, Clause 3. The senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and the several states, shall be bound. So there's right in the Constitution itself, Article 6, Clause 3. Members and bound will all be darned in the law of nations, regarded as international law, where our founders based the Constitution off of, and cites for the Constitution part where it requires in order to qualification to run for president is a natural born citizen. They say, see Vittel, section 212. Right here. That's where that comes from. That's right. So I debunked all of them citizen crap, or I should say national crap. All that is they're using the code, which is the corporate bylaws of the United States, Inc., and putting themselves back in under the involuntary bankrupted corporation. They've been led astray by Anna von Reitz. Sorry. The truth may hurt, but the truth nonetheless. Yeah, down here at the bottom here, I like to kind of give that deal here. I am man. Creation of God. That's this. Proper spelling. Right? Man. Kirk's Law Corner LLC with an ID number. This is in law. A person. Incorporated. Business license. For profit. Taxpayer. One of the people of the territory of Idaho. I know that's a hard concept for people to grasp, or for mankind to grasp, but nonetheless. Idaho Notary Public, there's my number there. Officer of the state of Idaho, I have an oath of office. I received, my license for notary says I've received all of the what? Emoluments and rights of the office of Notary Public. Emoluments and rights? Huh. Yeah, imagine that. So, there's just a little tidbit of national-assembly.net. Of course, you got the assembly introduction video. Takes you right to that. Definitely look at the resources and go right through these. Current situation. Where are we the people? 1638 fundamental orders, which is part of where we started with the General Assembly. The assembly supporting videos, that's a good place to start. Provided they're working again. Oh, looks like you took down a couple of them. There used to be about 6 here. But nonetheless, again, folks, I can only lead you to the water. It is up to you to take a drink. I cannot force you to drink this water. Some days I wish that I could, but it would do absolutely no good to force a man to do something, because they're not going to learn. And they're not going to like it. Not going to enjoy it. And I personally don't like forcing people to do things either. So it's kind of a catch-22. I'm not going to force you, and it's up to you to educate yourself. Okay? So it's up to you, folks. It's up to us, the people. All political power is inherent in the people. Okay? Trump said he was putting the power back into the people's hands at his inauguration speech in 2017. That power he's referring to is all of it. All political power. We have the right to alter, reform, or abolish anything at any time we deem it necessary. We don't need anybody else's permission. We have to come together. We have to bring unity. We got to come en masse. just the way it is. Okay. All right. Much love, everybody. Have a wonderful night. Thank you for tuning in. Make sure you like, follow, and share. Whatever channels you most like. I prefer you share Rumble, to be honest, and I'll share Rumble over here on Telegram like I normally do. After it compiles, which it seems to be working a lot faster than it was here a couple months ago. But thank you all for being here. Much love. Have a wonderful night. And Wednesday night for Patreon, we'll see you folks in there. And Thursday night, I hope people get over there onto the national-assembly.net. And if you're looking to join your particular state assembly and get involved, help assembling, whatever. You may already have a coordinator or moderator. You can send an email to contentmanager1, the number 1, at yahoo.com and say, hey, I'm from California. I want to be involved. I'm from Michigan. I'm from wherever. Michigan's already basically assembled. Alaska's already assembled. There's a few of them that are already essentially back to being assembled. Started. Basic stuff's been done. We need 38 states to assemble to take back all the power. And we get to kick everything to the curb. Otherwise, right now, what's coming is martial law. The military's going to come in, and it's coming. It ain't no joke. Executive Order 13818, December 20th, 2017. Blocking the property of those involved in serious human rights abuse and corruption. If we don't come together and unite and reassemble, it's going to come. I mean, that's basically what they're waiting for. But it's going to come to a point in time here shortly where the military is going to have to do what they got to do. So then it'll be taking out the governmental regime just like they've done in other countries. And the people are going to have to take the reins. The people are going to have to come together. So it would behoove us all, the people of America here, to come together and reassemble, like literally rebuild it, put it back together. The General Assembly. Take back our power and take back control. All right? God bless. Have a wonderful night. Catch you on